When I question a doctor during his pretrial deposition, how important is it for me to be familiar with the medical record that the doctor and the patient are involved in this particular case? You want to know the answer? Come join me on this walk through the neighborhood as I share with you the exact answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so now here's the scenario. You brought a lawsuit against your doctor claiming that he was careless and that his carelessness caused you harm and injury. And now your doctor denies all of your allegations. And he says, by the way, if I did something wrong, so did you, Mr. Patient. And he says, you know what? If I did something wrong and it caused you harm, guess what? Your injuries aren't that bad. So now, during the course of your lawsuit, I have an opportunity to go ahead and question your doctor, the doctor whom you have sued, in a process known as a deposition. It's really nothing more than a question and answer session given under oath, and it takes place in the doctor's attorney's office. So now, before I take one step into the attorney's office, is it important for me to be familiar with your medical record? The answer is absolutely. Not only do I need to be familiar with it, I need to know every single entry that took place in this particular office record. I need to know exactly what was done. I need to interpret every single entry in the doctor's record. I need to be able to have my medical expert look at those records and to tell me exactly what it says and what the doctor did. Why is it so important for me to be totally familiar with the doctor's medical record involving your care and treatment? Because that is the only possible way I can go ahead and question the doctor. I can't go in there and simply ask the doctor to read his record and say, okay, thanks, have a great day. That's not what happens in these medical malpractice cases. I'm going to ask the doctor to tell me in his own words exactly what he did and why. I'm going to ask him for his reasoning. And I'm also going to be asking him what is appropriate standard of care for your particular problem. And then I'm going to ask him whether or not he violated the basic standards of medical care. And hopefully, if I do it right and question him correctly, I can get him to voluntarily admit that what he did in fact violate the basic standards of medical care. That is the ultimate goal for this pretrial deposition. So now, is it important for me to be familiar with the medical record? Absolutely. Because if I don't know the nuances and the details of every single thing that he wrote and every single thing that the patient complained of and every single thing that went on during his interaction with the patient, I'm going to be at a significant disadvantage when I question him. And now I'll simply have to accept whatever it is that he says about what he did and why. It's critically important for me to be familiar with what the patient said occurred during these particular visits and interactions. It's important for me to know exactly what the patient testified to because, by the way, the injured patient will be questioned way before the doctor is ever questioned. As part of the lawsuit process here in New York, the defense lawyer representing the doctor will have an opportunity to question you, the injured patient, known as a deposition. And this will take place in our office. So you will be the first one to be questioned. And weeks or months later, now I have an opportunity to question the doctor. And then I'll ask him, doctor, if the patient did not have X, Y, and Z, would you agree that doing A, B, and C would be a departure from good and accepted medical care? And he has to say yes, right? He won't want to answer that question, but he will have to agree. And I will go through with him hypothetical questions that basically say, listen, doctor, if certain things were done, if the patient made the following complaints, would you agree it would be appropriate to do A, B, and C? And again, he has to say yes. Now, why do I do that? There are always factual disputes in these cases. So now, if I can get the doctor to accept for the moment that our version of the facts are correct, yes, in that instance, he would do A, B, and C, or that he should have done A, B, and C. Okay, doctor, looking at your record, is there anything to indicate that you did in fact do A, B, and C? Well, no, there's not. Well, can we agree that that would be a violation from the basic standards of medical care in that fact pattern? And he has to say yes. And that's the ultimate goal of this deposition. So why do I share this quick information with you? I share it with you because it's a gorgeous day today here in Great Neck, and I wanted to give you an inside look at what really happens in these medical malpractice cases in New York. You know, I recognize you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, @oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.